Good evening, everyone. Good evening. My name is Janet Levitt. I'm the Dean of the University of Tulsa College of Law. As your program notes, President Upham had hoped to be here tonight to introduce this program and our speaker, but he faced an irresolvable conflict and at the last minute couldn't be here, so he sends his regards. So it is my pleasure. I'm going to welcome you to the University of Tulsa for the 13th Annual John W. Hager Distinguished Lecture. This is a lecture series in law and justice, and it honors the memory of Professor John Hager, who was a devoted and influential member of our law faculty from 1950 to 1989. This lectureship has brought to campus distinguished scholars, Judge Richard Posner, Professor now Dean Harold Coe, Judge Guido Calabresi, and last year Professor Hiroshi Motomura. And as we carry forward the spirit and the memory of John Hager, we are honored this evening to welcome many outstanding faculty, jurists, mentors, friends, alumni, and students. Time does not permit me to recognize all of you, but I would like to take a moment to acknowledge the members of two groups in particular. First, I believe we have at least one trustee of the University of Tulsa here, Sharon Bell, who is a big supporter of the university and of the College of Law, and herself is an alumna of the College of Law. And second, I would like to acknowledge the many members of our TU Law Alumni Board who are here in attendance tonight. You do so much for the school, and we appreciate your commitment to the school, to our students, and to all the work that you do. So if we could just give you a hand. So tonight, we honor two men, Owen Fiss, the Sterling Professor at Yale Law School, and Professor John Hager, whose enduring spirit we remember today. I had the distinct privilege, the true honor, perhaps in my career, of working with Owen Fiss as a student, as a research assistant, as a teaching assistant. He is a cherished and beloved mentor. I owe him much credit for sparking my love of law, as well as my love in life, Ken, since we met in his class. I did not know John Hager. His death preceded my arrival in Tulsa and at TU. Yet I feel as if I know him, as his legacy exists in the crevices of this building and in the hearts and minds of so many former students, many of whom are here today. And it's my sense that our two honorees would have had much in common and would have engaged in a meaningful intellectual dialogue. John Hager was beloved as a master teacher, and I think it is very telling that there are two and only two portraits that hang on the walls of this school. At Yale, there are many more than two portraits that hang on the walls. Here there are two. The first is of John Rogers, the namesake of our school, and a very distinguished lawyer here in Tulsa. And the second is of John Hager, and this portrait was a gift from his former students. It was a sign of the mutual respect, of great mutual respect between student and professor. Now, Professor Fiss is a master teacher as well. In his book, The Law as It Could Be, he writes that the classroom is his workshop. He orchestrates the classroom like a brilliant symphony, and what's more, he He composes a new symphony with each new group of students. I will never forget my first day of law school, walking into Professor Fiss's class after reading Goldberg versus Kelly, which was actually the very first case I had ever read. It was actually about the only case that we read in Professor Fiss's procedure class. And I had absolutely no idea what was going on in this case, or even what the case was about. So I did what any law student would do. I walked into the room, had my head down, made no eye contact, and to no avail, I soon heard, "Judge Coven," that was my maiden name, "Judge Coven, what would you do? What would you have done?" That was the question. And somehow I was able to pull out an answer. I said, I would have ordered that the plaintiff class be provided with individual counsel. With that exchange, the semester-long dialogue between students and professor began, and it has never stopped. In addition to being a master teacher, colleagues describe Professor Hager as having gravitas. He was known as the king of torts, and he commanded instant respect from colleagues in the bar. Professor Fiss is a giant in the field of constitutional law and adjudication. Valedictorian of his Dartmouth class, magna cum laude, graduate of Harvard Law School. He was a law clerk for then Second Circuit Judge Thurgood Marshall, and then a law clerk for Supreme Court Justice William J. Brennan. He then served as special counsel to the Assistant Attorney General in charge of the Civil Rights Division of the Department of Justice. He joined the faculty, the Yale faculty, in 1976 after spending several years on the University of Chicago faculty. He is one of the most prolific and cited scholars in the field. It seems that as if he has published a book almost every year of his career. His CV has more articles than today I could actually manage to count, and his work has been translated into Spanish, German, Hebrew, Portuguese, Chinese, and Czech. Yet to know gravitas is to experience Owen Fiss in his role, and here I'm borrowing a term from another student, his role as constitutional law diplomat. Whether advising the Attorney General on criminal trials in Argentina following a brutal dictatorship, or drafting the Eritrean Constitution, or convening scholars from the Middle East to attempt to find common ground on questions of democracy and equality, the power of Owen Fiss's ideas, the power of his presence, transcends boundaries. So one more question I've asked some of my colleagues. If John Hager, the namesake of this lecture, was the king of torts, why is this Hager Lecture a lecture in law and justice and not a lecture in torts? Their answer was that the lens through which John Hager taught torts and taught everything was the lens of justice. And justice has been the unifying theme of Professor Fiss's career, from civil rights to questions of equality and democracy to human rights to, as you will see tonight, the war on terror. And an equally unifying theme is the role of law and the role of the judiciary as critical institutions to the maintenance of justice. So tonight, with the heartfelt gratitude of a former student who has never stopped learning from her beloved professor, with the intellectual curiosity of a scholar who is repeatedly drawn back to the strength and power of her mentor's ideas, and with the passion for law and human rights that flows from studying with someone so fervently committed to justice, I present to you Owen Fiss as the 13th John W. Hager Distinguished Lecturer.
I am greatly moved by the welcome. I'm greatly moved by the generosity of the introduction. I'm greatly moved by the occasion. Continue the dialogue that Janet spoke about. The room is filled with teachers, and I know all of you who are teachers know the special pleasure of being in the presence of a student of yours who has always been one of my teachers. And tonight, I would say it's a doubly special occasion because the student turned teacher has embarked on the deanship of this law school with as much commitment as she's taken to all the challenges of her life. I know that she is deeply committed to making this law school as great a law school as it could possibly be, diverse, vibrant, intellectually serious, and devoted to the highest ideals of the nation. I'm very pleased to be here, and I'm very pleased to hear and see Janet, not just as a student, not just as a teacher, but as the dean of this law school. My topic, as Janet said, is the war against terrorism, and I begin this lecture with the observation that that war is not yet over. The fight against terrorism predated the Bush presidency and will continue long after. President Obama has openly assumed the burden of this fight. He has assured us that swift and decisive action will be taken against terrorists, although he has also insisted that this action will be in accord with the Constitution. In his inaugural address, he declared, "As for our common defense, we reject as false the choice between our safety and our ideals." And on the first days in office, he issued executive orders addressing some of the abuses of his predecessor. Our task as lawyers and as citizens is to identify these abuses with some specificity and then to describe the action that is needed to put the Constitution right. In this lecture, I focus on one of the most egregious of all abuses, the policies and practices of the Bush years that put into doubt the American commitment to prohibiting torture. This prohibition is embodied in a number of international instruments, most notably the 1984 Convention Against Torture and the criminal statute that we enacted to implement that treaty. Yet it is important to understand, so that we can be clear about the magnitude of the wrong, that the rule against torture did not await the arrival of the 1984 Convention and its implementing statute. It is rooted in the Constitution itself. The Eighth Amendment prohibits cruel and unusual punishments, and torture would surely meet the standard of cruel and unusual. Although some may claim that torture inflicted for the purpose of extracting information from a person held in custody might not be deemed a punishment imposed for an infraction of a criminal statute, and thus beyond the scope of the Eighth Amendment, I maintain that such conduct is prohibited by an implicit premise of the Eighth Amendment. Certainly, if we cannot torture someone who has been judged to have broken the law, we cannot torture someone who we only suspect has broken the law, or who we believe is in the possession of information that might enable us to prevent or punish unlawful acts. Imminent in the Eighth Amendment is a principle, let's call it the dignity principle, that denies state officers power to treat inhumanely anyone in their custody. A similar regard for human dignity can be found in the Fifth Amendment. In the broadest of terms, that amendment denies the state the authority to deprive anyone of life, liberty, or property without due process of law. This norm has been construed to prohibit not just unfair procedures, but any action that shocks the conscience or offends elemental regard for the humanity of persons in state custody. The phrase "shocks the conscience" was used by the Supreme Court to denounce action of police that consisted of pumping the stomach of a suspect. As an expression of the dignity principle, the constitutional ban on torture of the Fifth and Eighth Amendment is an absolute. It focuses on the intrinsic quality of the state practice, its sheer inhumanity, and does not vary according to the alleged value of the information sought. The constitutional ban on torture cannot be overridden or relaxed because the interrogator believes he might be able to extract information that will save an innocent life, or that matter, countless lives. The harm to our cherished values would be far greater than the benefit that might possibly be obtained. At issue is nothing less than the ideals that define us as a nation. President Bush declared that he was opposed to torture, yet he governed in a way that put his underlying commitment in doubt. He declared his opposition to torture in 2004, almost 3 years after he announced the global war on terror, and did so in a most defensive manner in response to a public outcry initially provoked by the publication of the Abu Ghraib photographs and then compounded by the leak of internal memoranda of the Department of Justice and the Department of Defense. The first of these memoranda was prepared by John Yoo and signed by J. Beebe, then Assistant Attorney General in charge of the Office of Legal Counsel, and was sent to the White House in August 2002. The infliction of physical pain, Yoo and Beebe said, amounted to torture only when it was an equivalent in intensity to the pain accompanying serious physical injury such as organ failure, impairment of a bodily function, or even death. This requirement was not derived from an understanding of judicial doctrine or international practice regarding the range of permissible interrogation techniques, but rather from an extraneous source, social insurance regulations defining the conditions for paying medical benefits. Such an argumentative strategy seemed contrived and made the memorandum appear to be the work of lawyers anxious to tell their client what he wanted to hear. Yoo and Beebe seemed determined to broaden the range of techniques available to interrogators beyond the limits of the Fifth and Eighth Amendments. The Department of Defense memorandum, in this instance prepared by William Haynes, then General Counsel of the Department, and dated November 12, 2002, sought to establish guidelines for interrogating prisoners being held at the Guantanamo Naval Station. It divided a broad range of techniques into 3 categories. The practices in the first 2 categories, which included round-the-clock interrogations lasting up to 20 hours, and the use of stress positions like standing for up to 4 hours were deemed lawful and made available to the Guantanamo interrogators. The third category included practices almost universally understood as torture, including waterboarding, a technique that used a wet towel and dripping water to induce the perception of suffocation or drowning. Haynes said that the practices in this third category were forbidden, quote, as a matter of policy at this time, though he was quick to add that they might be legally available. Secretary of Defense Rumsfeld approved Haynes' recommendations with a handwritten note indicating, I stand for 8 to 10 hours a day. Why is standing limited to 4 hours? The announcement of the guidelines proposed by Haynes and approved by Rumsfeld provoked controversy among the generals. As a result, a high-level working group was assembled in the Department of Defense, and on April 16, 2003, Secretary Rumsfeld issued a new directive identifying the interrogation techniques that would be allowed at Guantanamo. 17 of those techniques were allowed by the Army Field Manual then in force. 7 techniques went beyond the manual, and in so doing, once again, put the rule against torture in doubt. One of the 7 was sleep adjustment, and the other isolation. By way of a parenthetical, the directive added that sleep adjustment is not sleep deprivation, and that isolation needs specific guidelines regarding the length of isolation, medical and psychological review, and approval for extension of the length of isolation. To further confuse the matter, the directive acknowledged at various points that some had contended that the technique authorized was inconsistent with protections afforded to POWs under the Third Geneva Convention. The Secretary instructed the interrogators to take consideration of such contentions, while at the same time insisting that the Guantanamo detainees are not POWs, but rather unlawful enemy combatants whose treatment was governed not by the Third Geneva Convention, but only by the lesser requirements imposed by the Fourth Geneva Convention. Torture is not self-defining, and for that reason disagreement will inevitably arise to whether a particular interrogation technique constitutes torture. The abuses of the Constitution implicit in the Defense and Justice Memorandum that I just described arose not from the very understandable need to provide guidelines for interrogators, but rather from the content of those guidelines, instinct with a desire to allow aggressive, indeed coercive treatment of prisoners without any regard for their dignity. Although our knowledge of the actual practices employed by government interrogators during the Bush years still remains fragmentary, the available evidence indicates that these interrogators fully understood the message being conveyed in these guidelines. No holds barred. In the case of the CIA, not covered by the Army Field Manual, not covered even by Rumsfeld's guidelines for Guantanamo, but only by the UBB Memorandum, the offense to the Constitution was especially blatant. According to a December 2007 television interview with an agent who had been on the scene, the CIA used waterboarding, the one technique almost universally condemned as torture, against a high-level Al-Qaeda operative, and did so under circumstances that made it clear that this was not the unruly action of agents under stress. The CIA interrogators in the field were in constant and immediate communication with the Deputy Director for Operations in Washington, and it was the Deputy Director who determined whether so-called enhanced interrogation techniques were to be used, against whom, and with what degree of intensity. No wonder Michael Mukasey refused in his confirmation hearing for Attorney General, which occurred shortly before this public disclosure, to say whether waterboarding was torture. He might have politically committed himself to prosecuting some CIA agents and their supervisors. Not only did the administration seek to narrow the scope of the rule against torture by manipulating the definition of the practices prohibited, it also denied that the president is bound as a matter of law by the prohibition against torture, and in so doing hark back to a conception of presidential power long identified with the Nixon White House. In the late 1970s, President Richard Nixon, in an effort to defend the action that led to his impeachment and eventual resignation, publicly maintained that the president is entitled to disobey the law whenever he determines it is for the good of the nation. If the president does an act, it is not illegal. History judged this view harshly, but it was taken as an article of faith in certain circles, which included Vice President Dick Cheney, and it became an organizing theme of the Bush presidency, most remarkably, even in the debates over torture. The conception of almost unlimited presidential power was defended by the Department of Justice and its Office of Legal Counsel. The 2002 UBB memorandum that I spoke about just a few moments ago not only offered a contrived definition of torture, but also put into question whether the president acting as commander-in-chief was bound by the prohibition against torture. In making this claim, UNBB treated the rule against torture as nothing more than a congressional command. Such a characterization of the ban on torture is a grave mistake, for it gives no effect to the Fifth and Eighth Amendments. Yet this view of presidential power is wanting on its own terms. Although the president, as commander-in-chief, might be deemed to have whatever authority is needed to prosecute a war successfully, account must also be taken of the constitutional grant of authority to Congress for military matters. Article 1 grants Congress the power to define and punish, and I quote, offenses against the law of nations, to make rules concerning captures on land and water, and to make rules for the government and regulation of the land and naval forces. The making of such rules surely would include the power to determine how individuals who are detained in a military situation might be treated or interrogated. The constitutional vision is one of shared power. Of course, under such an arrangement, conflicts between those who share the power may sometimes be in conflict. The era of UNBB, however, was to assume that in the case of such conflict, the president as commander-in-chief should prevail over Congress. They gave no reason for that view, nor is one readily apparent. The inadequacy of you and Bibi's view of presidential power is even more apparent when we focus on the Fifth and Eighth Amendment roots of the prohibition against torture. For all exercises of the powers of the President must comply with the Bill of Rights. This basic proposition of constitutional law is implicit, I say, in the very institution of judicial review, which empowers the judiciary to set aside measures of the President or Congress that might be within their enumerated powers, but inconsistent with the Bill of Rights. The understanding of presidential power propounded by you and Bibi even survived the repudiation of their contrived definition of torture. In December 2004, in the wake of the public outcry surrounding the leak of their memorandum, the Department of Justice issued another memorandum on torture. This one explicitly repudiated you and Bibi's definition of torture, saying all that is required is severe or extreme pain. But this new memorandum did not withdraw or in any way modify the you-Bibi view of presidential power. The new memorandum said it was unnecessary to address the issue of presidential power because the President had publicly declared as a matter of policy his opposition to torture. These concerns over the limit of presidential power were reinforced by the events surrounding the enactment of the Detainee Treatment Act of 2005. One section of that law, sponsored by Senator Lindsey Graham, denied the Guantanamo prisoners the right to seek habeas corpus. It made the system of military tribunals set up by the Department of Defense at Guantanamo, with limited review in the D.C. Court of Appeals, the exclusive mechanism to test the prisoners' claim that they were not enemy combatants. A separate section, spearheaded by John McCain, codified the constitutional ban on torture. President Bush fiercely resisted the enactment of this portion of the statute, only creating further doubt as his commitment to the policy that he publicly but belatedly announced in 2004. Eventually, he signed the 2005 Act, but upon doing so, issued a statement in which he explained that he was signing the measure with the understanding that the statute did not create or confer a private right of action on victims of torture. He also said that he intended to construe the statute in a way that was consistent with his constitutional powers as Commander-in-Chief and his duty to protect against future terrorist attacks. The legal significance of the so-called signing statement was unclear, but not its political implications. It was widely understood to indicate that President Bush did not believe himself bound by the act, and if military necessity dictated, he would allow prisoners to be tortured as part of an interrogation process. In keeping with its expansive view of executive power, the administration further diminished the Constitution by engaging in a practice known as extraordinary rendition that involved torture, though by foreign nations. Extraordinary rendition is distinguishable from the more common form of rendition, in which the executive, acting outside of a formal judicial proceeding, delivers an individual to another nation to stand trial. In extraordinary rendition, the executive, also acting outside a judicial process, sends an individual to a foreign nation, not for purposes of putting that person on trial, but rather for interrogating that person and extracting information from him of use to the United States. The predicate of such a transfer is that the nation receiving the prisoner will use aggressive and brutal interrogation techniques, yes, torture, that the U.S. agents are not prepared to use. Although this practice antedates the Bush administration and the global war on terror, it was used with notable frequency in the Bush years. There are indications that it had been used for about 60 to 70 times during the period. The element of outsourcing entailed in extraordinary rendition is of no legal or moral significance. If the Constitution prohibits United States officials from engaging in a certain practice, then it also prohibits those officials from creating an arrangement whereby officials of another nation do the prohibited action. Imagine, I ask you, imagine prison officials who do not actually torture prisoners in their custody, but rather turn the prisoner over to other inmates to do what is denied them. These prison officials can be faulted not just for the transfer, but also for the torture that occurred through the arrangement they created. The dignity principle eminent in the Fifth and Eighth Amendments binds the United States and all those who act on its request and in its interest. A more difficult legal question presented by extraordinary rendition, and the one that might have been lurking beneath all the torture debates of the Bush era, concerns the territoriality of the constitutional ban against torture. Americans are fully protected by the Constitution, no matter where they reside. Yet they have not been the target of extraordinary rendition, nor have aliens who are residents of the United States. With one possible exception, extraordinary rendition has only been used against foreign nationals living abroad. For example, a German citizen traveling in Macedonia was seized by CIA officials and taken to Afghanistan for interrogation under conditions of torture. An Egyptian citizen was kidnapped by CIA agents on the streets of Milan and taken to Egypt for interrogation under conditions of torture. The one possible exception to this rule concerns the extraordinary rendition of Maher Arah, who was seized by immigration officials on September 26, 2002 at JFK Airport, held virtually incommunicado for 13 days in nearby detention facilities, and then sent to Syria via Jordan for the specific purpose of interrogation under conditions of torture. Arah brought a suit in federal court to test the legality of his rendition, which, due to the involvement of immigration officials, was implemented under the auspices of the Department of Justice rather than the CIA. Arah's suit was dismissed by the district court. A panel of the Second Circuit affirmed that decision, and the matter is now pending before the Second Circuit sitting in Bank. The case was argued on December 9, 2008, in the closing days of the Bush administration, and is of special significance to me and the nation. Arah had only the most fleeting connection to the United States. He was born in Syria, and by virtue of that is a citizen of Syria. He moved to Canada with his family as a teenager and resided there ever since. At the time of his arrest in 2002, he was 33 years old, and by that time had become a naturalized citizen of Canada. Arah had been vacationing with his family in Tunisia and was arrested when he was returning to Canada for business. His itinerary took him from Tunisia to Switzerland and then on to JFK, where he was to take a flight to Montreal. Transit passengers at JFK, as many of you know, need to clear customs, and while online waiting to present his passport to an immigration official, Arar was arrested. The arrest was based on a tip from the Royal Mounted Police of Canada, later proved to be false, that identified Arar as a member of a terrorist organization. After his brief detention in the United States, Arar was flown to Syria, where he was imprisoned for 10 months in a grave-like cell measuring 6 feet long, 7 feet tall, and 3 feet wide. He alleged that during the first 12 days he was interrogated for some 18 hours a day and also severely beaten during that interrogation. The interrogation ceased when Canadian officials interceded on his behalf, but Arar remained incarcerated in his grave-like cell for 9 months more, at which time Canadian officials were able to secure his release. From my perspective, Arar's imprisonment and interrogation violated the United States Constitution. This conclusion is not derived from the fact that he, unlike the German or Egyptian citizens that I mentioned a few moments ago, was arrested on United States soil, specifically at JFK Airport, and imprisoned in the United States for a number of days before. He was only a transit passenger who was arrested before being able to effectuate the transit. His entitlement to the protection of the Constitution derives not from his brief and guarded presence in the United States, but from the notion that the Fifth and Eighth Amendments and their ban on torture are applicable to officials of the United States and their agents wherever they act and against whomever they act. These officials are not allowed to torture anyone, regardless of where they capture the victim and regardless of where the torture takes place, whether it be the United States, Switzerland, Tunisia, Canada, or Syria. The Fifth Amendment purports to protect, and I quote, any person, and the Eighth Amendment is of like import. It is cast as a flat prohibition with no effort to delineate the group of persons protected, and it should be viewed as defining the outer limits of the authority of American officials. More fundamentally, this view of the reach of the Fifth and Eighth Amendment derives from the underlying value at issue, a just and proper regard for the dignity of each person held in state custody. Human dignity is violated whenever someone is tortured and wherever the torture takes place, and becomes a violation of the United States Constitution when that torture is inflicted by United States officials and their agents. This broad understanding of the Constitution is reflected in the provisions of the Detainee Treatment Act of 2005, which prohibits torture by United States officials wherever they act and against whomever they act. So does the federal statute criminalizing torture. It specifically prohibits torture by United States officials acting outside of the country. Of like import is the very recent decision of the Supreme Court invalidating the statute denying habeas corpus to the Guantanamo prisoners, all of whom are foreign nationals. Admittedly, the court in that case did not determine what substantive right the Guantanamo prisoners had, But the very act of extending the constitutional protection of habeas corpus to these prisoners necessarily implies that they had some constitutional rights, the most basic, for otherwise the writ would be of no utility. This interpretation of the recent Supreme Court decision accords with the general view of the legal profession, and the constitutional tradition of which it is a part reaches all the way back to the insular cases of the early 1900s. One of these cases posed the question whether the Sixth Amendment guarantee to trial by jury was applicable to the Philippines, which was then being held as a colony. The Supreme Court concluded that the Bill of Rights was not in its entirety applicable to the administration of an unincorporated territory such as the Philippines. Yet the court qualified that holding by declaring the United States officials were always bound to respect the fundamental rights of all persons living within the territory. Among the basic or fundamental rights is the right against torture. In an unincorporated territory, such as the Philippines, the United States is the sovereign. Similarly, the United States could be deemed to exercise a de facto sovereignty over Guantanamo. No such claim of sovereignty, whether formal or de facto, could be made about Syria, where Harrar had been transferred and interrogated. Yet it is difficult to understand why the geographic site of the torture, whether it took place on American soil or in Syria, has any significance in determining the applicability of the Fifth and Eighth Amendments ban on torture. What makes the constitutional ban on torture applicable is the fact that the torture is inflicted by American officials or others acting on their behalf. The dignity principle that drives and guides the interpretation of the Fifth and Eighth Amendments is person, not place oriented. Pressed, I'm unable to point to a Supreme Court decision that clearly and authoritatively announces such a rule. Accordingly, I must acknowledge that the willingness of the Bush administration to engage in extraordinary rendition may reflect not an indifference to the Constitution, but rather a genuine dispute over its territorial reach. Such a lawyer disagreement, if that's what's at stake, would surely have made the need for judicial termination of the lawfulness of the practice all the more appropriate. Yet rather than defending on the merits the extraordinary rendition of Harrar and others, and seeking a resolution of this issue, the Bush administration invoked a number of doctrines, some alas very technical, that call for the dismissal of the suit without ever reaching the merits of the substantive claim, either as a matter of fact or law. At this point, the judiciary could have stood up for the Constitution and denied the motion to dismiss, thereby discharging its most elemental responsibility, but the court chose another course instead. It granted the government's motion to dismiss, and in my judgment, in so doing, became complicit in the administration's assault on the Constitution. Vice President Cheney and his assistant David Addington may have been at the helm of a small cabal directing this assault on the Constitution, as some have contended, but they would have not been able to achieve their purposes and diminish the Constitution in the ways they did if other institutions, most notably the judiciary, had not allowed them to have their way for as long as they did. The lower federal courts based their reluctance to examine the legality of the extraordinary rendition program on a number of grounds. One related to the remedy sought. An injunction would have not been appropriate in this case because the victim of the rendition, such as Ira, who miraculously secured his freedom and was able to bring suit in federal court, could not demonstrate the likelihood of recurrence. So he sought a declaratory judgment and damages, a declaration that he was wrong, and compensation for that wrong. Every lawsuit rests on a legal claim. When an injunction is sought, the Constitution itself provides the claim without the need for any congressional authorization. The same rule applies to declaratory judgment. Although a congressional statute passed in the 1930s made the declaratory remedy available in federal court, the cause of action or claim underlying the request for that remedy arises much like that for an injunction from the Constitution itself and does not need congressional authorization. In the 1971 Bivens decision, Bivens being the name of a case, the Supreme Court extended the same principle to damage action, though with one qualification. The court held that a claim or cause of action underlying a request for damages for constitutional wrong arises from the Constitution itself, unless there are some special factors that might make it appropriate to require congressional authorization. In the Ira case, a panel of the Second Circuit treated the foreign policy and military ramifications of extraordinary rendition as such a special factor, and on that ground disallowed Ira's claim for damages. The court said that it had to dismiss the claim for damages because there was no congressional authorization to award damages. Such a ruling seems odd in the extreme. Congress, unlike the judiciary, is a political body, but that does not give it any expertise or special competence in matters of foreign or military policy. Moreover, unless the special factors exceptions to the Bivens rule is going to degenerate into a free-floating political question doctrine, long discredited by the Supreme Court, it's not clear why the characterization of Congress as a political institution constitutes a reason for the judiciary to await congressional authorization before allowing damages for the violation of a constitutional right. Although there is a long-standing tradition of the judiciary deferring to the executive in matters of foreign and military policy, that deference does not belong to Congress and does not in any way depend on the nature of the remedy sought. Wholly apart from the question whether a statute is needed under the terms of Bivens to create a claim for damages, the government sought to defeat Ira's claim for damages by making reference to a doctrine known as the qualified privilege. According to this privilege, damages will be awarded only if it can be shown that the officials being sued violate a right that had been clearly articulated at the time they had acted. In the Ira case, the Bush administration did not deny that the right against torture in some general sense had the requisite clarity, but only that it was uncertain that the right extended to foreign nationals who were tortured on foreign soil by foreign officials. Accordingly, there would be no point, the government continued, judging the constitutionality of extraordinary rendition, because even if it were unconstitutional, damages could not be recovered by Ira due to the qualified privilege. The qualified privilege invoked by the government serves two purposes. It avoids the unfairness of holding the government liable for damages for conduct that was not understood to be lawful at the time it was undertaken. It also avoids creating disincentives for taking forceful and innovative action in a context where the legality of the proposed action is uncertain. I am doubtful that either purpose would be served by a ruling that put extraordinary rendition within the protection of the qualified privilege. Granted, there has been no clear ruling, as I acknowledged before, on the legality of extraordinary rendition, but given the universality and force of the norms and law against torture, it should be clear to government officials acting in good faith that the practice runs afoul of the Constitution. More importantly, even if the claim for damages must be dismissed without reaching the merits, either because of the qualified privilege or because of the Bivens exception, the claim for a declaratory judgment remains unaffected. The declaratory judgment does not require any congressional authorization and does not penalize any past act. It simply declares the law. It's an exercise of the core judicial function. It enables the judiciary to remove any lingering uncertainty as to the legality of extraordinary rendition, and in that way restores the sovereignty of the Constitution. The Second Circuit panel decision held otherwise and dismissed Arar's claim for declaratory judgment on the theory that he lacked standing required by Article 3. There was no doubt Arar suffered concrete injury. The question was whether the declaration, in contrast to the damages, would confer a concrete benefit on Arar. Worried about standing, Arar's lawyers artificially defined the declaration sought. The complaint did not see the declaration of the unconstitutionality of the rendition to which Arar was subjected, but rather the invalidity of the removal order that was issued against him in order to effectuate the rendition. The Second Circuit panel denied, however, that a declaration of the invalidity of the removal order would be of any benefit to Arar. He had been designated as a member of a terrorist organization, and as long as that designation stood, the panel reasoned he could be denied permission to enter the country, and if so, a judgment on the validity of the removal order would not confer a concrete benefit on him. Sadly, Arar's lawyers fell into a trap of their own creation. The focus of the declaratory judgment should not have been on the removal order, but rather on the constitutionality of the practice of extraordinary rendition. Rule 54C of the Federal Rules of Civil Procedure gives a court the authority to enter any order that is just, and Arar should not be precluded by the strategic decision, possibly a blunder, of his lawyers. To my mind, Arar had Article 3 standing to obtain a broad declaratory judgment on the legality of the rendition to which he was subjected. Concrete harm should be sufficient. We all suffer when someone is tortured because the basic law of the nation is compromised. But the victim of the rendition suffers a distinct and very particularized way. His personal suffering constitutes an injury in fact, and it should entitle him to invoke the power of the federal judiciary. As a purely formal matter, such a declaratory proceeding would constitute a case of controversy within the meaning of Article 3. It also seems that the policy objectives served by the standing requirement are satisfied. Arar has every incentive to make certain that the contentions of law and fact are vigorously presented. The claim tendered is the same as would be presented in any injunctive proceeding, the government acted in violation of the Constitution, and respects the inherently legal function of the judiciary to say what the law is. Concrete benefits should not also be required, but if they are, they can be found in a Raw's case. The declaratory judgment does not contain the material component of a damages award, but much like a damages award, it speaks both to the world and to the victim. It says to all the world that the government violated basic norms of the legal order. It also addresses the rendition victim and tells him in a direct and personal way that he has been wrong. High officials in the United States government violated the basic law of their nation in sending him to Syria for interrogation under conditions of torture. Such a statement may have as much meaning to the victim and give him as much satisfaction as an award of damages. It helps restore his sense of self-worth. It speaks to his soul, not to his pocketbook, but there is nothing in Article 3 that prioritizes the material over the spiritual. Yet, still another avoidance technique employed by the judiciary to dismiss the suit by the victim of extraordinary rendition. The state secret doctrine honors the very understandable need to conduct some of the business of government in the dark. The doctrine was first announced in a case involving a tort suit against the United States for a death arising from the crash of a military airplane. As part of the discovery process, the plaintiff sought internal government documents relating to the construction of the plane, and the Supreme Court held that the refusal of the government to surrender those documents was correct. The plaintiff was allowed to continue the litigation, though without the benefit of certain documents in the possession of the government. As originally crafted, the state secret doctrine operated only as an evidentiary privilege, but has been transformed during the Bush years into a de facto grant of immunity. In another lawsuit regarding extraordinary rendition, this one brought against a private contractor that the CIA allegedly had engaged to transport the prisoner to the site where he was to be interrogated and tortured. The state secret doctrine was used not to withhold some evidence from the plaintiff, but rather to dismiss the suit in its entirety. The district court reasoned that any inquiry into the validity of the rendition would compromise the secrecy of the CIA. In so transforming the state secret doctrine from an evidentiary privilege into a de facto grant of immunity, the court threatened the rule, long the hallmark of our legal system, that subjects all government officials to the Constitution, even the CIA, and entrusts the judiciary with the task of determining whether these officials have violated the Constitution. This use of the state secret doctrine overlooks the distinctly public purposes of the suit before it. In this instance, determine the legality of extraordinary rendition. The request for damages would make the suit seem similar to the run-of-the-mill tort suit, such as one seeking damages for a death resulting from a plane crash, inasmuch as it has both a private and public dimension. On the other hand, the request for a declaratory judgment, absent in the ordinary tort suit, accentuates the essentially public purpose of the suit and thus must be weighed against the government's claim of secrecy. If the damage claim is precluded either by the qualified privilege or the exceptions to the Bivens rule, then the court should begin its analysis of the state secret doctrine by acknowledging the essentially public character of the suit and the danger presented by dismissal. Honoring the state secret doctrine, any time a clandestine agency such as the CIA or one of its instrumentalities is charged with violating the Constitution, would in effect place that agency beyond the reach of the Constitution. Finally, apart from the state secrets doctrine, and regardless of what remedy is sought, account must be taken of the reluctance of the judiciary to second-guess the executive on foreign and military matters. Courts labor under a constitutional tradition that calls for judicial deference in such matters, and for that reason will be hesitate to inquire into the merits of the rendition victim's claim. Admittedly, the executive possesses a special competence in defining the foreign policy's objectives of this nation and how those objectives might be pursued. The executive also has special competence to determine how a war should be fought, what military action is required for a victory. Yet the executive has no special competence when it comes to determining whether the challenged action, even if it is of a military nature or implicates foreign policy, comports with the fundamental values of this nation. Indeed, such a determination is the essence of the judicial function, to determine whether extraordinary rendition, even if fully required by foreign policy or military objectives, is consistent with the dictates of the Fifth and Eighth Amendments. On that issue, the executive is likely to have a view, as I suspect the Bush administration most certainly had, but it is owed no deference. The authority of the judiciary over such questions of value arises not from the personal virtues of those who happen to sit on the bench, but rather from the strictures of public reason that govern all exercise of the judicial power. The need of the judiciary to listen to all those who are aggrieved, to try the questions of law and fact in an open courtroom, and to justify its decision on the basis of public principle. On January 20th, 2009, the Bush presidency was brought to a close, and we seem to have entered a new era. President Obama immediately issued executive orders addressed to some of the abuses of the previous administration. He confined the CIO, at least until further study, to interrogation techniques set forth in the Army Field Manual. He closed the secret prisons, the so-called black sites maintained by the CIA, and he required the closing of Guantanamo in a year's time. All of this action should be applauded because it has the inevitable effect of minimizing the risk of torture. Black sites and Guantanamo entered our legal lexicon as prisons in which foreign nationals were abused and maybe even tortured. Moreover, having the CIA governed by the Army Field Manual will at least nominally place the enhanced interrogation techniques of the CIA off limits. Following this initial flurry, the signals sent by the new administration have been decidedly more mixed. To his credit, President Obama declared at his first press conference that he's opposed to torture. In his first address to a joint session of Congress, He spoke, as I do, of the example of America, and once again declared his opposition to torture. His nominee for Attorney General, Eric Holder, in a clear attempt to distance himself from Bush's last Attorney General, Michael Mulcahy, began his confirmation hearing by declaring that waterboarding is torture. On the other hand, no order was issued by President Obama barring the practice of extraordinary rendition, and at his confirmation hearing, Leon Panetta, President Obama's choice to head the CIA, equivocated on whether extraordinary rendition would be used by his agency in the future. He was unprepared to send someone to another country, he said, for the purpose of torture or action by another country that violates our human values. But he also added that he might be prepared, without providing the subject of the rendition any procedural protections, to return the person seized to another country where they prosecute them under the law. Only time will tell whether these concerns I've just voiced about the future policies and practices of the new administration are justified. Even deeper misgivings relate to the past and the willingness of the new administration to take appropriate corrective action for the constitutional wrongs that occurred over the last 7 years. At his first press conference, the President, when asked to comment on Senator Patrick Leahy's proposal for the establishment of the Truth Commission, said that he was more concerned with the future than with the past. Fully in accord with the sentiment, Leon Panetta announced at his confirmation hearing that CIA agents engaged in torture, including waterboarding, in the early phases of the war against terrorism, would not be criminally prosecuted. Nor has there been any indication that the new administration would disavow the many strategies used by the Bush administration to avoid a ruling on the merits on any of the suits brought by victims of extraordinary rendition. To the contrary, in an argument before the Ninth Circuit last month, in the suit against the CIA contractor that I mentioned before, lawyers for the government once again relied on the state secret doctrine and thus seemed prepared to confer de facto immunity on the CIA for constitutional wrongs as gross as those entailed in extraordinary rendition. A willingness to speak only to the future is not sufficient. Not only must the new administration establish policies that preclude torture in the future, it must also account for the wrongs of the past. It must prosecute those who engage in practices clearly understood to be torture and provide civil remedies to those who are in fact tortured. In that spirit, it must disavow the doctrines that led the judiciary to avoid the merits of the claims of victims of extraordinary rendition and allow these cases to go to judgment. Such action would lend credence to the lofty rhetoric of the President about the future. It would bring to light the way the Constitution has been abused and enable the public to confront and acknowledge the violations of the Constitution committed in their name. The public would have an opportunity to say, nunca más. These proceedings would also allow the judiciary to affirm the dignity principle and the constitutional norms to which it gives life, and to declare in bold and clear terms that these norms apply to American officials and their instrumentalities wherever they act and against whomever they act. Thank you.
Professor Fiss has agreed to take a few questions. It's late, but maybe 3 or 4 questions. It's obviously, as you can see, a teacher is always a teacher and presents ideas in a way that are very provocative, and we'd love to hear from any of you.
I hope not. I hope we have learned the lesson of that long and bitter experience. It did take a long while to officially recognize the errors of the internment program. But, you know, in the intervening decade since that occurred, American constitutional law has developed in extraordinary ways. And I would hope that at this point of history, we don't have to wait the 30, 40 years that we waited before. I don't think the American public or the American bar should tolerate that kind of delay. It's implicit to some extent when President Obama denounces torture in the way that he does and receives, for example, the warm reception that he did receive in the joint session of Congress. But I don't think that's enough. I think we need to come to terms with the past and take concrete action to discover exactly what transpired and whether these actions were a violation of the Constitution. I think it's necessary to go forward in the constitutional tradition that has been built. It's conceivable that one could imagine a moment of decision in which the president felt that if he didn't pursue X course of action, the whole Constitution and order of the United States would collapse. I'm not sure how I feel about that. I would probably say that the action, if it's unconstitutional, is unconstitutional, and that the president cannot be judged by the law but by history. But I don't think that's what we have here. I mean, I don't think that's what the record indicates. I think there's a kind of, if you look back at these documents that provided the architecture of the policy for this period, it's not this existential moment in which we're deciding in the Lincolnist fashion the whole nation and Constitution may come apart. I think if you look at the policy, it's kind of an indifference to the Constitution, and it's an indifference to the values that are served. It's an indifference to to human dignity that is, I think, at the essence of the Fifth and Eighth Amendment. It doesn't make an appearance. It doesn't make an appearance. It's a conception of unbounded presidential power, but not at the moment of the existential crisis that's invoking the name of Lincoln, but rather of kind of a different philosophic stance towards the Constitution altogether. And that's what I think needs to be re-examined.
Dr. Fiss, Owen, I can't quite do it. Thank you. Thank you so much for enlightening us all and joining us here in the European capital of the heartland.